And we're live. Good morning, everybody. Welcome to Senate Economic Development, Housing and General Affairs. It is Friday morning, May 9th, and we welcome you to our committee, where today we are going to be trying to get our workforce development bill out, and we are going to begin the day with looking at a challenge we have faced for many years now in this committee, H106, an act relating to selling real estate within a FEMA mapped flood hazard area. And to start us off, we're going to have Representative Debbie Golgan come and introduce the bill. She represented it on the floor. You are the reporter. Welcome.
Can we testify together?
You may indeed. And Debbie, I'm not sure you have met all of us.
No, I haven't.
Okay, so we're just gonna go around the room because you're a new representative from St. Johnsbury, the Northeast Kingdom, right?
Do you live in St. Johnsbury?
Yes, I do.
Okay, great. So we're gonna start with Thomas.
Hi, Debbie. I'm Tom Chittenden. I represent the southeast quadrants of Chittenden County.
Keisha Rom Hinsdale, we're in the same district.
Allison Clarkson, Windsor County District.
Randy Brock, Franklin County and Northern Grand Isle.
Good morning, David. Dave Weeks, Rutland County, and I live in Buck.
Oh, that's yeah. Oh, well, thank you so much for inviting me to talk about H106. This was, we changed some language to try to make things more transparent.
So, and you are?
Oh, I'm sorry. I'm So it was to make things transparent in a transaction. So we set some guide rails on what the buyer needs, the buyer's responsibility and the seller's responsibility. So we changed in the original bill, it said a buyer, and we changed it to a seller of real property. They have to provide and disclose information.
So committee, we have 106 as passed by the House on our desk. So we have.
Right, so you can look at, let's see, section 1, part C. They talk about the seller, and he has to provide information. Anybody that's bought real property, you all know what those forms look like that the seller fills out, and they check what I know and all that stuff. So we want to include the FEMA flood maps in that. So if the seller does not disclose that information, the buyer can, and then the buyer finds out where they can end, I don't want to buy this property. I don't want to buy it, and there's no problem. They can back out, but the buyer could also seek for damages, if they had to have a lawyer, any damages that they incurred because they backed out of this purchase. But the seller, we're going to protect the seller a little bit too. And they're not going to be liable for damages if they go through this process of locating their property on a flood map. So it has to be done in a sequence where it's documented. So you can't just say, it hasn't flooded here in 2 years or whatever. You can't just say that. You have to go through and document. You could get testimony from somebody that you believe would know.
The neighbors.
Yeah, you could. Oh, well, you want somebody of authority.
That's true. You're right.
Well, you have listers, assessors.
Yes, there's people.
My neighbors know a lot.
So actually, I did it in my own town. I went to St. Johnsbury and said, hey, you got those FEMA flood maps? And we go, oh, you can just get those online. It's simple. And I said, okay. So, but that was a first step. I'd want to document that I went to the town, what information they gave me. And then I could document, going to the website. I can even print out FEMA maps of my area and what that would look like. So
can I ask, did you,
oh, yes.
when I first started trying to do that, I like had to download some ArcGIS software or something.
Oh, to
Maybe
make,
things
yeah.
have changed in the last year. I need to go get my glasses also. Is this just a regular website now? Because before, I actually thought, this is
This is
hard.
FEMA.gov.
Very
Okay, so we're gonna get to this in a second,
Yeah.
yeah.
You didn't have to download anything.
No,
And with regular internet speeds, it was
Yeah.
easy to see.
well, I mean, I think I live in high speed. so
Yeah,
I
yeah.
can't answer that.
So I just did it 10 minutes ago.
Oh, good. Okay, because I haven't done it in a while, and before I was like, if I can't figure this out.
Okay. Go get your glasses.
I'm going to get my glasses.
Debbie, keep going, because then we're gonna go to Peter.
Introduce.
You're next.
Okay.
Oh, okay.
That Debbie introduced so she can get back to committee.
Okay.
Well, I assume you have committee meeting. Oh, okay.
We have four members. So the main thing is you want to document what research you did and to share with the buyer what you found to be true. And also non-compliance it doesn't really affect the marketability of the real property.
And your vote on the floor was a voice vote?
Yeah, we did have a vote, passed 10-0-1
In your committee?
in my, yeah.
And it was, and then on the floor, I assume it was a voice vote?
Or roll call.
It wasn't a roll call. I think, it was in with another bill.
Oh, it got incorporated in another
I
bill.
think
No.
so. Was
It
the
can't
other
be, or
one?
we wouldn't be looking at it here as
Okay.
H106.
Okay.
Well,
Sorry.
Okay,
Peter
so
Tucker
Peter,
from
would you be
Vermont
kind enough to
Association of
introduce
Realtors,
yourself?
just so I can comment.
Right.
And it was on a voice vote and it passed, pretty close.
Oh, yeah.
So, yeah.
Great.
I don't think it's.
So Peter, welcome.
Thank you.
Introduce yourself if you would, and
Sure.
go for the gusto.
Peter Tucker for the Vermont Association of Realtors. This is an issue, we addressed this flood disclosures last year. Our testimony was highly about the fact that it is a material fact on a property and, that buyers should be made aware before they offer basically, whether or not they want to buy the property and then also at what price they want to buy. They should be informed so they can make that informed decision. And that's, really kind of a basic tenet of our organization is to make sure that material facts are provided up front. What we didn't realize was the form of the disclosure was going to be so challenging. And, that's, so we put it into action. We got it. We
Good.
figured
that's
out
a
how
very
to deal with it.
charitable way of saying it, Peter, because at the time we worried about that.
Mhm.
And I'm sorry, it's just taken us a little bit of time to get to this, but you had highlighted that it was likely to be an
We
issue.
were concerned about FEMA maps, but we didn't really understand the depth of it
Correct.
until we kicked it open to 1,700 realtors who had probably 1,700 different opinions of how it works. Well, and I'm good to go now?
Yes,
Okay.
absolutely.
So,
Debbie, are you sort of done with your war report summary?
Yeah.
You're just gonna keep going with Peter, because you don't have committee. Great.
Right.
Well,
okay, that's
Okay,
great. Yeah,
you're
'cause that
welcome.
was super. It was her first bill to be introduced on the
did
floor.
you get
She
Raz?
did a great job. Yeah.
This
And-
is a really important one because honestly,
is.
it was when the legislature has to own up to a mistake in some way. That's hard to get past sometimes, so I think it's
Okay.
good.
And I will be honest with you, I was in the room
Right.
and I did not anticipate how poorly the maps were gonna perform. So, I really appreciate the fact that then Chair Stevens, kind of took the bull by the horns, even though he didn't end up being Chair of House General this session, and introduced this bill.
Great.
So, the original introduction was to just eliminate the two FEMA map questions. It's just too challenging, we shouldn't do it. However, Representative Haley said, gee, I'd like to, kind of have something that requires the seller to at least take a good faith effort to look at the maps. And, what I have up here, it's Orleans, I believe, the Willoughby River. Anyone can help me with the zone. I tried to call up a FEMA map, and this one is probably from like 1995, something like that. And I would estimate,
Can you make it a little bigger?
I hope so.
Just so.
The plus sign over there,
What's that?
click map to zoom in on the
Oh, yeah,
sign.
oh, I see, it's on.
You've got our tech whiz at your, right
There.
next to you.
And then I can do this, yeah.
I don't know that we'd see anything more the closer we come.
Come on. There we go.
Oh, good, keep going.
Yeah.
Brandy and I down here are saying,
Okay.
oh, great, perfect. No, that's good.
It's that little small bar all the way to the left.
Right here and just, oh.
Great.
That's good, there we go, okay.
Okay.
I'm good. So, this is a typical, what is called a paper map. It was a FEMA map from like 1990s that was scanned in, and this is your FEMA map. So I happen to know that the zone A's are high flood hazard areas and medium flood hazard areas. These are the two areas that need to be disclosed.
And we're looking at Montpelier?
No, this is,
Say,
I believe it's
Barton and
Orleans.
Willoughby.
I'm
Yeah.
sorry, you know, what I tried to do is grab an old map that would represent the challenges here.
okay,
And the challenges are, I mean, even in zone A3 here, you can see there are no roads delineated, there's no property lines, there's no way to determine exactly where your property is, in or out of that zone.
got it.
I'm trying to see which, like, main road, is that 58? Are we
Yeah,
looking at,
58
like,
right
that's
here.
why I
Main-
thought it
Main
said
Street is
state.
Route 58, yes.
Okay,
So I thought, Peter, that our listers had property overlays on this. Most of them.
So maybe, and so, well, in Montpelier, yeah, I mean, you can actually
Right.
click on a span number and get your exact location. But this is the challenge, it does
Right.
not really overlay very well or at all. And then you need to know your zones, and let me just, if I can, I'm gonna get out of this.
Did you say it's the town of Barton?
It could be, I thought I did Orleans, but you're right,
No,
it's
I-
up there. But what I can tell you is that 50-60% of the state have maps
so
like this.
I'm trying to like, this would, my
You're proving your point.
in-laws are from Orleans, and my mother-in-law grew up right across the street from the Ethan Allen factory, which,
Oops, sorry.
if this is 58 and this is Main Street,
Yep,
no one told me to this who's watching, but I mean, like, somewhere here is the Ethan Allen factory,
Mhm.
and then you drive through and you can go to like the old stone house.
right, right.
It's a lovely area, everyone should visit.
And
Yeah,
I'm sure the Willoughby River is lovely too when it's,
when it's
Hey.
within its banks, yes, indeed.
whoops, we just lost.
Yeah, I know, because I wanted to move to a good FEMA flood map. if I may.
And those things are going very, very, very slowly.
I mean, slowly but surely, and let's face it, I mean, Montpelier, this will come up in just a second. Montpelier has a great flood map, it's digital. Come on, Dave. And just take, I guess it's a big, yeah. And so here, I know that you can see the legend down at the bottom. And that the special flood hazard area is in blue. Much of the State House is just above it. So this is down around the corner a little bit. But at any rate, you can zoom in on this map and you can get right down to, property locations. And then it's gonna take a second to reload. And then orange areas are the medium flood hazard areas. So, this is good for me.
Oh,
It's in
that's
color.
very, yeah.
It's in color, city of Montpelier. You get a somewhat of an idea of buildings and that sort of thing.
So sorry, the blue shaded is all flood
Is
prone.
high flood hazard areas, yes, indeed. Yeah, and then the hash marked areas are actually the river corridor, the regulatory corridor. So this is pretty good, right? Like, and I mean, some towns have it, some towns don't.
Right.
I want to relate one story that happened almost immediately when we did this, was the city of Johnson. And the city of Johnson had a 25, 30-year-old flood map, And, you know, because Johnson flooded so severely, you know, FEMA said, well, we'll update that map. And they did update it. And then the town council said, the new map is actually worse than the old map. It doesn't really describe where we saw flooding. And probably the first 2 months that we had this thing in action, Johnson had no flood map. So there was no ability of a seller to disclose anything
yeah.
because they had absolutely no map to work on. And I would say 10 to 15% of the state have no FEMA maps. I would also indicate that those are not areas that there's a ton of residential housing in, right? Like, I mean, you know, they're probably higher elevation areas and things of that nature.
And my understanding from when we looked at this last biennium post flood is like, you can see it says effective 2013. Even when they update them, they're about a decade old after that. Like right when they hit, they're a decade old. So it is really, it's really dissatisfying for those communities.
And given what's happening at the moment with FEMA, and it is given how dependent we are on these maps, it's very disconcerting right now that we are, because they've updated some, but what percent of the state has been updated?
So it has this digital map is 35 to 40%. You know, I'm not precise. If I look at the whole state map, it's really hard until you start drilling down to know what's where. But that's you know, I'm pretty close on my estimates. So the challenge has been twofold. You know, the challenge one is, you know, people who have the old paper FEMA maps that can't really figure out where their property is located on it. The other challenge is sellers who just don't have computer capability, right?
Yeah.
Like their inability to actually go on a computer, log into you were able to get on the FEMA website easily. It's not too hard, but, you know, but they just don't have that skill set, you know. It is the seller's responsibility. You know, we work with sellers all the time. We assist them, but, you know, it's not our legal responsibility. So when I said, hey, I'd like to get rid of the two FEMA map questions, and you may remember S311, you guys only asked for, do you buy flood insurance? You know, that was the only question that the Senate started with. And then, you know, this kind of got going in the House and you accepted their language. You know, so those are the two challenges that are faced. Representative Mahaley, who introduced this language, well, Cameron introduced the language, but, you know, to say a reasonable effort has been made to determine whether you're in a high or a medium flood hazard area. You know, there was another discussion of what is settled, you know, kind of a settled term, but a reasonable effort would include things like calling your town clerk and saying, hey, am I in a FEMA high or medium flood hazard area? And the town clerk says, I can't interpret from that.
Right,
you know?
exactly.
But it's some reasonable effort to at least have taken a look at a map or to ask somebody who has expertise about, you know, the map. And, you know, if you can't determine it, then you would not be held liable. And that is the language that's in this updated bill.
But Peter, surely towns grand list and listers, the listers have history on each property, that they keep records on each property. There is a record of what has happened. There is
and
a
that would be a
flooding
reasonable, right. That
So
would be
that
reasonable
strikes
effort.
me as the effort that would count in this case.
Yes,
I mean,
I would agree.
this property is flooded in Irene, this property flooded in 2023 and 24. I mean, that,
But it was the way how specifically it was worded when it passed would put more liability on a seller than that.
right.
And that is not fair.
So
Yeah.
now we're liberating the seller to be able to use this and to use that kind of an information like a flood history, even if the town didn't have these maps.
Because,
Right.
I mean, and I think what Peter would say is, if you have a good realtor, they're trying to figure out every time the basement flooded and everything you
Right.
should know.
Yeah, I mean, flooded from a broken pipe or things
Exactly,
of that nature,
exactly.
you know, those are just
That's
as
a little different.
important, but it's
Right.
very different from this disclosure.
But if you
So-
don't have a realtor,
Mhm.
you really do need to be doing your due diligence and not expecting the seller to
Right.
have done all of it for you.
Great, thank you.
How accurate do you find these maps? Have you found discrepancies in them?
The discrepancy is in the paper maps, you just don't know where your property is. That's the challenge. And
Well, I
in a
see,
map
for
like this,
example, in the maps that the state does in terms of geolocation, I found them to be somewhat inaccurate, in fact,
Property lines
frequently inaccurate,
shifted or,
that, you know, a property is labeled with the wrong address, for example, which has happened to me.
Yeah. Occasionally, I guess I wouldn't say that's consistent, but it, you know, once again, are you using like a GIS overlay and that sort of thing? You know, the more.
Well, what I'm
layers you
saying,
have.
are you finding differences between the GIS produced by Vermont in its project compared to what you see in the FEMA maps, or do they tend to agree?
They tend to agree.
Like, they're
as a
both
matter of fact,
updated in
They're
the
pulling the data from FEMA
Right.
for the state maps. One other concern that has been pointed out by our members is on amendments. So this is the city of Montpelier, beautiful digital map. There are 44 amendments to the map in Montpelier.
And it goes to you.
And without going through every single
Yeah.
amendment, how do you know if your property doesn't have an amendment on it?
So the amendment doesn't get immediately incorporated into the map?
No, it is, and most of them are like, you know, somebody did a flood
Yeah.
level certification for their property, and they say, hey, I'm out of the flood zone, but the map is showing me in the flood zone. Yeah, it doesn't update the maps, it just says, here's an amendment that proves that I've done my flood cert and I know what my base elevation is, so. So that's just another challenge even for folks that have pretty good maps.
Yeah.
Um,
Can I ask?
With the administration's proposal to eliminate FEMA, do you have any ideas of what's going to happen with mapping at all? Whether it's something that's going to.
No, that's what I tried to raise just a minute ago. I was very
I
concerned.
mean, I think we're kind of fixed in place. I mean, I don't imagine a lot of progress being made in the next, 3.5 years.
In case you has a question on that.
Well, Peter, you're doing a great job speaking for like the much broader
Mhm.
world of mapping out there. What I've noticed on like Zillow, listings or whatever.
Yep.
Is that they have a flood risk number. A lot of them say the flood risk is 7 out of 10. Woodstock had that, for
I
example.
was gonna say, you did this with Woodstock.
Yeah, I did. I
Both
sent
little
something else and I'm like, this is a home they're trying to sell for $4 million that has a 7 out of 10, flood risk. Like, what does that mean? So do you all look at I don't know what that flood risk is on
I have
Zillow.
no idea what it is. I gotta be honest with you.
That's so interesting because I imagine that's what most people end up looking at when
Sure.
making market decisions.
Yeah, it's real easy, that's the beauty of Zillow is they're just little
Yeah.
tools that,
And they're probably basing it off some algorithm that pulls this data, but
right.
I honestly have no idea.
Mhm. Yeah.
So this is the disclosure form?
So this
Seller's
is our
disclosure.
current disclosure. We haven't made any changes to it. So the challenge that we have faced is that the Act 181, the language last year said you must disclose whether you're in a high hazard or medium hazard area. It's a yes or no question. But what we found in practice is there are people that just can't figure it out.
Right.
So the language in this bill, and I'll defer to Ledge Counsel on the exact language, says if you put forth a reasonable effort, you cannot be held liable if you can't figure the maps out.
Right.
And, so the way I've described it going in was to say yes, no, or I cannot determine. So we would like to probably add a category for the first two questions that says I cannot determine. Now, question 3, has my property flooded during the period of time I've owned the property? That's very straightforward. Are you buying flood insurance? That's very straightforward. The other thing on these two FEMA map questions is going to be an explanation box that we would like to add. And
Peter, just on the question of, has the property flooded since I've owned it? What if they've only owned it for a year?
but if they
I
have,
mean, there isn't a question that asks, what's the flood history in the property?
Well, that's what we have to ask.
the problem that
The
we
seller
ran
wants
into,
to know.
how far
Question
back-
1 and 2 would address that.
Yeah, exactly. And that's why I think Representative Hale
Oh, the
wanted
ones
to keep
that-
those
that-
questions in.
Right.
Because that would be more indicative
Right,
of
okay.
that.
I
The
just
other
can't see what questions 1 and 2 are. They're the
one
ones in the
is,
box.
FEMA special flood hazard area, that blue area that we
Right.
looked at on the Montpelier map, or a medium, a moderate flood hazard area, which is actually in
Okay, so
orange
those are the first.
section.
I
Those are
can't.
the two questions, sorry.
It's okay.
Yeah, and so I think that we really, we want the sellers to disclose. We just found the way we were going about disclosing to be incredibly challenging in many parts of the state. And for, an aging population, you know, that doesn't have good computer skills, like myself.
I'm curious about question 4, does the seller maintain flood insurance
Yes,
on the real property? Because there's always been a difference between being required to and being able to afford to.
right.
So I don't know if,
It's just another indicator. If they
no, I know,
do
but
have it,
it's funny what Senator Sanders' office recommended to us when we were doing the bill and working with them closely was, is there a requirement to maintain flood assurance on the property? Because that's what 30+ states do, that's the only thing you have to disclose. Is there a requirement to carry flood insurance, which actually kind of captures all the other factual information that you would need to know. So it's interesting to me that we're asking if they do maintain flood insurance.
As opposed to if they're
We're
required.
realizing flood insurance is harder to get and
Right.
harder to
well,
afford.
then, one of the answers may have to be, I don't know if I'm required to or not, but question 1 and 2 move you more towards the direction of,
No, I'm
this
just
is-
curious because saying, does the seller maintain flood insurance is really different than,
Yes.
like, how much does it cost? You know, I mean,
Well,
Sure.
if you're required to, so it's an
If you have a
interesting.
mortgage,
And many of us have found out, and many of our constituents found out, as they applied for buyouts or they applied for assistance
right,
and found they were ineligible
yeah.
if they did not have flood insurance.
gotcha, yeah.
So,
So, I think that let's go back to, you know, why do we want this disclosure? You know, we
Mhm.
want it at the time that the property is offered for sale so that the buyer can make an informed decision. And I think that the map questions staying in there, you know, provide some guidance. The other part that we want to add to this particular form, and this is a Realtor form, this isn't, you
Okay,
know, but just, you know, I wanted to give you a kind of an idea of what we want to accomplish.
but it's, okay, so it's interesting, you said it's a Realtor form,
Yes,
but it says at the bottom, the sellers completed this form personally and they're made by the seller, not
Yes.
a representation made by the real estate agent.
see,
yes,
is it possible to blow this up a tiny bit?
yeah, blow it up.
Well,
Sorry.
not blow up the contract, but blow up.
Enlarge.
Yeah, enlarge. Are you?
Move this one.
Yeah.
Oh, there.
You know where
And there's my
you are?
box, yeah.
We are a few blocks outside.
Off the flood zone, really?
Okay. And the other thing that we
Thanks.
want to add here,
So let's
you
see,
know,
go down to Keisha's question at the end.
Can you
Yeah.
tell me more about
so I mean.
why this is written this way?
Because that's the language from Act 181.
But aren't you trying to help the seller make an accurate?
yeah, but who's responsible? It's a seller. not
Oh, the seller's
not the
responsible.
The
Right.
seller is responsible.
Yeah,
But the real estate agent, so the real estate agent has no responsibility? If the seller could then
If it's
go,
misrepresented, they wouldn't know.
right. So the seller has the information, right? You know, about has the property flooded, you know.
but, so you were saying you, as a real estate agent, wouldn't be the one to go check the maps and try to help them make the best determination?
But they
We would
but
help, but it's the seller's
they're
disclosure.
not responsible for the proof.
They're liable.
Is
Yeah.
that the same as every other disclosure, that ultimately it's the seller's word?
Yes.
Okay, I just wanted to make sure this
And
wasn't
not
some special way of
others.
saying.
Yeah,
it
we're not
because you
trying
wrote
to,
the
I mean,
lawyer.
and,
Okay,
you know,
yeah.
we help. And
Right, right,
honestly, if I'm a
yeah.
buyer's rep, I'm probably checking it out. you know,
Yeah,
because,
absolutely.
You know, I'm not liable, but
Right.
I want my buyer to be informed.
Right,
Good reputation.
Yeah,
yeah,
and this is really, you know, the goal is to make sure the buyer understands the property before they make an offer on it.
Mhm.
And I think that these questions do a good job of doing that. You know, the reality is, you know, we were always gonna try and disclose that, right? But, you know, it was the form of the disclosure with these
Right.
FEMA map issues that we ran into,
yeah,
that we just wanna have some flexibility there
yeah.
for a seller who has really tried and can't figure it out.
Great. Where does, I guess I'm trying to assess whether, how the seller can also use the history of the property
Hmm.
in lieu of the map, if the map hasn't been updated.
Mhm.
How have you provided for that, Cam? Or are you gonna walk through, well, you'll walk through this and we'll see. But I don't see that here.
What was determined in House General last year was that, you know, a seller can't, you know, I mean, if you wanted, what's the history of the house?
Yeah, but
You know, if that's a
the history
question
goes
you
beyond
ask.
the cellar. The history
Yeah.
goes into the,
But
into
the
the
seller
cellar.
only has, you know, the only knowledge that they could kind of, you know, actually, you know, provide is knowledge during the period of time they've owned the house. And that's the, you know, that's really,
Well,
you know,
it's pretty limited.
I mean, they may have some, you know, some information about previous history, but
So, and anything else before we turn to Cam, either to walk through it, or Jim and, Chris?
Yep, no,
Anything else?
I think, you know, I've explained, you know, what I wanted to show you, and I think that.
The map
this
is
a-
very telling,
Yeah, and that's just one map, I mean. if I
and
start
that's
going
only at
around the state-
35 to 40% of the state now has a map that good.
Well.
Oh.
Yeah, but even the old ones give you indications that you ought to be, that there's a risk and you ought to be sensitive about the topic.
Mhm.
That's
Yeah,
the point.
Because water moves and shifts.
Well, actually, that's the first,
Yeah, that's
the first page of the FEMA site, you know, that's exactly what they, you know, what they say is, you know, our maps are only good for a certain period of time because, you know, yeah. You know,
Well-
because floods do change.
flood, yes, they do, and that is one of the first challenges we looked at. The flood things we use, and we're at pace with flooding. Great, we're gonna have Cam
Thank you.
quickly walk through it, then we're gonna have, Chris and Jim. Jim, it's good to have you join us again. Great. Debbie, thanks. I know you're now on the floor, lucky you. Oh, no. Okay, Cam, it's yours.
Yeah, and that was literally her first presentation of the bill, so I thought it was, you know, it's
Oh,
a
great.
three-pager. It was a three-pager, so it was a good one to start with.
Yeah.
Well, length has no correlation to importance. Some people would.
Can we click on that?
After last night's cabaret, maybe we'll restrain ourselves.
Good morning.
Good morning, Cam.
Cameron Wood, Office of Legislative Counsel. I'm going to walk through 106 as it was passed out of the House. For some reason. There we go. Okay. H106. Act letting selling property within a FEMA mapped flood hazard area. I'm going to quickly walk through this section. This was in Title 27, which is the title related to property. And this is related to conveying real property. And as was mentioned, this section passed last year. It became effective. So you have in sub A, the seller has to provide this information to the buyer, whether the location is in a FEMA mapped area, whether the real property was subject to flooding or flood damage while the seller possessed the property, and whether the seller maintains flood insurance. As was mentioned previously in sub B, the failure of the seller to provide the information is grounds for the buyer to terminate the contract. Subsequently, if the buyer purchases the property and finds out that the seller, failed to provide the information, the buyer can then bring action for damages. And then you have in sub D, there's a protection for the seller if the seller is relying on information provided to the seller by a public body or a person with a professional license or special knowledge. If they're relying on that information and disclosing to the buyer, then it's a defense against damages. And then lastly, in the sub E in the current section, non-compliance does not affect the marketability of title of the property itself. So what this bill will do is, first off, in subsection C, so this is the top of page 2 here, I just didn't really like the language as it was, drafted. It was, a buyer who fails to receive the information, and that just doesn't really make sense to me how it was worded there. So it should really be if a seller fails to provide the information, then the buyer can bring damages. So that's really more of just, kind of technical language change in that section. But just understand, if a seller, the responsibility here is on the seller, it's not the buyer. Seller fails to provide the information, the buyer can bring the action, right? So the key piece then is really in this D2, this subsection D, where, as you can see, D1 is the current language. So as I said, if a seller is relying on information provided to them by a public body, so their town, or an individual with a professional license or special knowledge, who's providing them with the information to answer the questions to give to the buyer, if they're relying on that, then that's a defense and they can't be held liable for the damages. What is being proposed is to add this subdivision 2. If the seller, after reasonable attempt to identify whether the location of the real property is within a FEMA map, special or moderate flood hazard area, notifies the buyer that the seller cannot reasonably determine if the real property is located within a special or moderate flood hazard area, and the seller notifies the buyer of the requirements of subsection A. So key kind of conversation that happened in House General, you want the seller to make an attempt. They shouldn't just be able to say, hey, I don't know. And so if they make that reasonable attempt and they can't ascertain whether they're in a FEMA mapped area, they're notifying the buyer of that, but then they're also having to notify the buyer, by the way, subsection A requires me to notify you of this information. I think the key point is to just make sure the buyer is aware. So as was mentioned, the buyer can then go do their own due diligence or have their agent go do their own due diligence, etc. So this was put in subsection D, so it would be a defense. So if the seller does this, then the buyer can't subsequently bring damage or bring an action and receive damages from the seller in the event that it is in fact in a FEMA map flood hazard area.
Great, Thomas.
So do you feel that this can be interpreted to allow for yes, no, or unsure? Because I'm worried that if they say, no, it's not in a flood map, but they did a reasonable attempt, I feel like that's not as accurate of a picture as saying on the form, unsure, and then clarifying with it. But this language can be interpreted to allow for the unsure option.
It says that they have to notify the buyer that the seller cannot reasonably determine. So, the other piece, I'm going to get to your question, because the other piece is you also have to notify the buyer of the requirements of subsection A. I don't necessarily want to opine on how a third party might draft their forms.
Okay. But you don't see
Unsure. Unsure without disclosing the requirements of the subsection, and I'm the buyer and I find out about it, I'm probably going to try to get damages from it. And I'm going to say, you haven't met your burden of demonstrating that you couldn't reasonably determine and you didn't notify me of the requirements of this section. If there's a disclaimer on the bottom of the form that says, 27 VSA, 380 requires me to disclose this information, and it says unsure, I think you've probably met the requirements of the section.
Okay.
I don't know if I were you, Peter, but I'd like a reaction to this. I would have a section that says cannot reasonably determine, and then I would have a comment box and allow for an addendum that said, like circles, like here we are on this map from the 70s, and like this is all the information.
And that's where I agree. I agree. So like if you're
Yeah.
a buyer and you just say, I don't know,
That's not
Right.
I wouldn't, and that's it. There's
Yeah.
no contract with, a real estate agent, et cetera, et cetera. You're just buying from someone and you're like, hey, I don't know if this is in a FEMA map area. I would say that probably doesn't meet the requirements here.
that's not us, that's them. They create the forms.
Right.
Third parties.
I mean,
Right.
Cool.
Right.
Well, it's them if they have a realtor, but it is, it's still for the best that we try to encourage people to have this conversation in as
Here,
clear a way
here.
as possible.
And that just leads me to a question, which is, Peter, how many sales, you represent real estate in the State House, how many sales are done with a realtor versus not?
Great question. So I did research and I think it was probably 23, looked at actually property transferred, total volume of transfers, versus, you know, what we did. And it's a little hard to figure because the transfer tax or the transfers are in different categories than we have in our multiple listing service. But it was roughly 3/4 of the transactions done by the real estate community. So 25%, 30% private sales, for sale by owner, things of that nature. You know, I would want to do an update to be more accurate.
Yeah.
But that's kind of what
But
I
roughly
saw
a quarter
previously. And it's
of-
ballpark, and it's, I think year to year is probably.
And you take a huge risk doing it solo unless you actually know a lot.
Right.
I can't imagine not doing it with a partner.
I don't know how a seller who is not using a realtor has any idea at all
I
that
don't
this is
either.
a requirement, other than maybe their attorney at closing going, you know, you've got to make this disclosure or else you're potentially liable. So,
Right,
you know, there was no effort to inform sellers, you know, generally.
right. Cam, anything else before we switch to Jim and Chris?
Not for me,
Okay.
unless you have any questions.
Great, let's move to Chris and then to Jim.
Thanks. Oh, right. Oh, that's true. Yes, thank you. Can I sit for a second?
Well, you just tell us,
Okay,
Chris,
sure,
because we
Chris,
just
jump in.
have 15 minutes.
So, yeah, and Chris reminds me that, that need to make sure that they had a period of time to create the new form, and it has to go to our executive committee and then to our full board of directors. So I would like to, the one change that I've talked with Representative Haley that he's okay with would be to make an effective date of September 1st on this bill, as opposed to on passage. The on passage thing is really what caught us last time, you know, off guard.
So you're proposing September 1,
September 1, yep,
25.
yep.
Great.
Thank you.
Chris, welcome.
Good morning. For the record, Chris Delia, President, Vermont Bankers Association. Welcome to the crazy world of flood maps and flood insurance. Senator Ron Hinsdale, to your question of Zillow, they use climate risk data from a First Security technological company that creates their basis of information. FEMA does not do that.
That sounds more accurate, honestly.
So,
I mean,
right.
just at first blush, like,
So I think
That
Zillow's
sounds more
looking
accurate.
more at guessing at what's happening in the climate
yeah,
and how changes are impacting
I
their
mean,
basis for
right.
the number that they're putting out there.
We looked last biennium at the Climate Vulnerability Index,
Yeah.
which in my mind is probably, when you looked at their map, it was more accurate to what had happened in the last 2 flood events
Right.
than FEMA's maps are at all.
Right.
Okay.
So we're supportive of the proposed language coming out of the House. We're supportive of the effective date that Peter just mentioned. This is a complex issue. FEMA maps in many cases are not up to date. They take a long time to get up to date. And as Peter showed you, there can be multiple amendments on the maps. So it is a bit challenging when you put it in the context of liability for the seller to truly identify and be accurate in their representation as to the property being on a flood map or being part of the amendments. From the perspective of our industry, the way we reach certainty as best we can is we use flood certification companies because they have the expertise to look at these maps on a regular basis. But even those determinations sometimes are inaccurate, and that's why in the FEMA regulations, you have an opportunity as a property owner to challenge that. There is a cost because you have to hire your own engineer to go out and do a site assessment. But with that information, you can submit it to FEMA and get an amendment for your flood determination. But this
Hence
seems
all those amendments in Montpelier.
that some of it, yes. But I think the approach that you've got in H106 is a reasonable one. It does provide some relief for the seller who does make that good faith effort to determine where they sit on the FEMA maps or the amendments to the FEMA maps.
Any questions for Chris? Right, you could stay there. Jim, welcome.
Thank you.
We need to hear you. You're now muted.
Okay, there.
Okay, now you're fine.
Hang on.
Good.
According to
good
my
work.
system, I'm not muted.
Right, you're fine.
Okay, all right, here we go. So for the record, James Knapp, I go by Jim. I am the co-chair of the real estate section of the Vermont Bar Association. For those of you who don't know me, I'm presently retired. I practiced law in the area of real estate for 42 years, representing buyers, sellers, and people financing real estate. So I am familiar with the flood hazard maps. I find it interesting that for the entire time I was in practice, the one universal concept was that every lawyer who dealt with any client related to a title examination always had a disclaimer that said, I'm not able to determine whether or not your property is in a flood hazard zone. So, I want to go all the way back to the beginning of the concept of this. Disclosure is important. It certainly is reasonable to ask the seller to disclose whether or not the property is flooded during the time that they've had possession of the property. It's certainly reasonable to ask the seller to disclose whether or not they have flood insurance. I like the suggestion that was made a few minutes ago, also to disclose whether or not you're eligible to get flood insurance, because those really are two different things. You may be required to have flood insurance if you have a mortgage on your property, because Chris's clients are going to insist on flood insurance if they're holding the paper on your property. But if it was a cash purchase or a bare piece of land or something else, you might not get flood insurance. And probably if it's a bare piece of land, you can't get flood insurance, because I think there has to be a structure on the property to have flood insurance. So, setting those two things aside, which I think are perfectly reasonable, here's the question I want to ask. And yes, I realize I am at the end of 3 years of consideration of this, but nonetheless, here's the question. If the information is equally available to the seller and the buyer, because the flood maps are public documents, the information in the town office is public information, why is the seller assigned a significant liability if either party can go and look this up? Now, let me talk about significant liability. Your statute says reasonable effort. If each of you was in a separate room and given a fact scenario about whether or not Jim Knapp did something appropriate within the statute to figure out if his property that he's about to sell is in a flood hazard zone, but we're not talking about being able to just pop onto FEMA and look at one of those pretty colored maps with the overlay with the with your property lines superimposed on it, which, by the way, to the comment that was made earlier, those property lines, remember, are not surveys. They're made up by someone who may or may not have any experience whatsoever in preparing maps. The fact is that in several towns, the tax maps were put together by graphic designers, not surveyors, not engineers, and not people who understood real property. They just wanted to fit the little boxes together. So if you've got access to one of the more recent FEMA maps or the Agency of Natural Resources Environmental Atlas, then yeah, you've got a reasonable shot at figuring out if your property is in the flood hazard zone. But if you go back to those paper maps, which is what I grew up using, they're hopeless. Your best bet is a ruler, and you figure out, well, my property is about 3.5 inches from the intersection of these two roads. And so if I put the scale on the FEMA map, well, it kind of looks like I might be close. But it all goes back to the question, if the buyer can do that as well as the seller, why is the seller liable? But to my example of the 4 people in the room, if I asked all of you the same question, I bet I get 2 different responses. Yes, it was reasonable, and somebody's going to say, no, it's not reasonable. So who determines what's reasonable? A judge. When does the judge determine what's reasonable? After two parties engage in litigation, each of whom probably spends somewhere between $20,000 and $50,000 in legal fees and other costs to make the determination. You can't use the word reasonable and assume that everyone knows what that means.
What would you suggest, Jim?
I don't have a good suggestion. There isn't a way, there isn't a way to do this other than to ask, other than to go through a series of steps that says there is a current FEMA map on which the property lines are overlaid and the property is shown in one of the shaded zones. There's a FEMA map with no lot lines overlaid. I can't really determine it. There's no FEMA map. What if, in a particularly bad situation, and there will be a bad situation, there will be a circumstance where someone bought property, they didn't understand it was in a flood hazard zone, and promptly after they move in, there is a flood event and they suffer damages. And if that could be avoided, that would be the ideal circumstance. But the issue is what's reasonable is going to be colored by the fact of the circumstances that arose. In that circumstance, people are going to impose a higher obligation on the seller to have done something because somebody was hurt and we have to fix it. In a worst case scenario, is someone going to say, well, the only way that you can reasonably say you are in or not in a flood hazard zone is to hire an engineer to do an assessment, which is going to cost the seller a couple $1,000s to get it done.
So your question for us is reasonable. It opens up some debate about what reasonable is. How do we define reasonable for your purposes? And you don't have a suggestion of how to replace it. Cam, in the House discussion, was there discussion about something that was a little more, less open for debate than reasonable?
I'm trying to recall the different conversations we have. In my kind of articulation and discussion with the committee, it's what was kind of just mentioned by Jim. I don't know what you replace other than reasonable, because the only other thing you can, from my perspective, my legal advice to you and in drafting it, the only other option is to get so prescriptive to, as Jim was mentioning, if it's this map, then you have this responsibility. If it's this type of map, you don't have that responsibility, but you need to go to this person to ask the question, and then that's going to be your defense. We use a reasonable standard in, a significant amount of your legislation. And
right.
Yes, it's a
we use it regularly.
And as long as the seller is, has taken steps to protect themselves, especially with, I think the key points here are notice to the buyer of what, the information that the seller has. And if the seller says, I reached out to my town, this is what they gave me, here's the map, I can't determine it. Oh, by the way, here's subsection A, so you're aware. I don't know how a buyer is going to be able to bring a successful claim against the seller to say that you owe me damages when I've gone out and done all the research for you and gave it to you. You were on notice.
Right. Any question? Jim?
The only last thing I would say is I think the interesting statement that was just made was a successful claim. You don't have to be, you are imposing an obligation on a seller to defend themselves against a claim that was that they're going to win. But by making the seller responsible for making these determinations on these maps, which are good, bad, and indifferent, you are putting a person in a position where they are going to have to defend themselves, which, bear in mind, in my world is somewhere between $20,000 and $50,000 of defense costs.
I get that, Jim. I get that, but the seller has a lot to gain. The seller is selling a property. In many Vermonters' lives, that's their largest asset. So
They are.
seller, why the seller is responsible? Because they're selling something. And they have to, if we sell anything, I think we have to know what we're selling and stand behind it. And I think it's absolutely appropriate that the seller be responsible for before they put something out and make personal gain, that they own its and understand its history. Thomas.
Some uncles and aunts that are realtors, and I remember them always talking about full disclosure, just they're obligated to just disclose everything.
Yeah.
So isn't that consistent, Mr. Knapp? Isn't
It
this
is.
consistent with mandating full disclosure?
It is, but is the realtor obligated to go into your house and go down in the basement and take the insulation off your basement walls to see if your sill is rotted? They have to disclose if they know it is,
But a good
what's the level of inspection that you have to
Yeah.
do. And,
But
and
Jim-
here, my sense is the information is available to both parties. I'm not
Right.
saying you should get rid of the disclosure for what I know. Has my property flooded? Do I have flood insurance? Absolutely, that is an appropriate piece to be in the statute. I'm just concerned that asking people who don't have any skill set to look at technical engineering drawings and make a conclusion from them, and then saying, and by the way, if you're wrong, you could potentially owe a lot of money. And even if you're right, but people don't like the answer you gave them, you could potentially owe a lot of money. I think this is too much of a burden to put on a seller. Yes,
Can I-
tell people what you know, tell people what you, in effect,
Don't.
should know.
Right.
But don't
that
make
is
me
fact.
go out and do an
Right, yeah.
engineering analysis to figure out if my property is in a
Okay.
flood zone.
Jim,
I
I
think
just
Keisha
wanna,
has
I
a-
just wanna back you up, because when we were disagreeing with the House on this one, we were trying to figure out how you stick to just factual information. And when you ask people to look at a map as subjective and outdated and maybe good, but maybe in most of the state not good, that doesn't even have a way to zoom in, that we should not pursue that route. I was hoping we would fix our mistake with going back to what 30 plus other states do, which is to say, you know, here's the flood map and I carry flood insurance or should carry I'm required to carry
Right.
flood insurance. This is what Bernie Sanders' office encouraged us to do, is align with most other states in this case. And I would be hard pressed to hear from any advocates of other proposals that another state is doing what we are doing, because that form is as good as you can make it. But I truly think it opens people up to liability, and they're going to be arguing about a map that's horribly
Right.
outdated, and who's right in that case. So, I mean, honestly, if I just am trying not to be difficult about every bill the House sends us, but this is not a good idea. It's the best idea to do what 30 plus other states do and ask the seller to provide factual information and nothing more, nothing less.
So,
So I will just say the language you have in 106 provides a little bit more protection than what is currently in statute, but, you know, you all, these are policy decisions that you all make about whether you feel that this is, you know, should be required responsibility of the seller, et cetera. I mean, I agree with Jim in that sense. It's, the language here doesn't prohibit buyers from bringing a claim that a seller would then have to defend themselves. It's just giving a seller a little bit more ability in the cases where it's difficult to determine whether a property is in a map, giving them a little bit more of a protection against damages in the event that they've made that reasonable attempt. It's not shielding them from a claim of damages or claim of liability. So
I mean, I showed you the $4 million listing with a 7 out of 10 flood risk in your community. if I were the buyer or potential buyer in that case, that should be enough for me to make the best decision for my money. And it's probably more accurate. And to then
Yes.
purchase that property and go after the seller, you know, when what they could point to, that's, I mean, I don't want to speculate, but maybe more accurate than anything the seller could provide is climate vulnerability indexing. It makes me feel like we shouldn't put as much responsibility on the seller as was originally contemplated by the House 2 years ago, because there are better ways to make this determination, and it seems like a way to just open up a seller to liability that's unfair where maps are really poor.
And to your point, that house is not sold yet.
Right.
Because who would,
Exactly.
do we have, I mean, because I appreciate the effort that this is going to protect, you know, also to improve the realtors forum and to help in these sales and to clarify things. Is there a way for us to reframe this in a factual basis so that instead of using reasonable, that we could use language that was more specific without being prescriptive, but just saying we'll disclose all the facts known or facts known to
I think the challenge that you have, and sorry, I was trying to jump on Zoom again so I could bring the language back up. I mean, I think the challenge that, as I understand it, that you all are working with is what you already passed and what is currently in statute. Because it's currently a requirement of the seller to notify the buyer if
Right.
they are in
So-
one of these maps.
right. So how can we, Thomas?
So, for the second time this week, I took a swing at some alternative language, getting rid of reasonable. And so if I may, I took Cameron's very apt language and I pumped it into Gemini, which is, and I asked, rephrase this to be more specific, that does not use reasonable. And they came up with something.
Are you
that-
trying to take Cameron's job away from him
I'm not
with
trying to
Gemini?
take Cameron's job away, but this is it right
Hey,
there,
I'm sorry
Cameron.
to doing that.
I can share it on the screen too, if that's all right. And I was delicately setting
So
that up.
who
I'm
is
not
this?
taking
Is this
your job
Tom
away.
or is this Cam up here?
No, this is the bill
Okay.
right now.
So Thomas, what's your suggestion?
Yes, let me share my screen, if I may.
And he can hijack the screen. Look at that.
So this is what Gemini said as an alternative to reasonable. If the seller certifies, and I did pass it by Peter Tucker, I was gonna send it by Cam, I just figured this conversation, if the seller certifies that they have consulted the publicly accessible online flood map provided by the Federal Emergency Management Agency for the specific address of the real property and notifies the buyer that based on this consultation, the seller cannot definitively determine if the real property is located in them. So the bolded language is what's replaced.
Right.
I still think Cam's a better lawyer than ChatGPT, and this would have started, so I just thought I'd get rid of the reasonable use.
So interesting, and maybe I think after our discussion, it's more than just FEMA. It would be, in addition, it would be the climate vulnerability map, some other mapping sources or other flood mapping sources, and I would say, and the lister's office. I mean, the history of a property is in the lister's office, and that's a fact. Those are facts that the seller could also use, it strikes me, yes.
So here, and here's where, things that shouldn't, I would want to sit down with this a little more than just, you know, on the fly talking to you, but here's some of the conversation I had with the House General Committee.
Right.
The question for me is, you know, to what, starting one, as Jim mentioned, what level of responsibility do you feel should be on the seller to
This is a
provide
big
some
handle.
information, okay? And if you think that they should have to do this research and provide information to the buyer of whether the property is within a FEMA mapped area, then the question is just what
For a flood map area, I think.
Right, one of the FEMA mapped areas, yeah.
Mhm.
The question is what.
That's all we can rely on, FEMA maps, which are getting more.
What level of effort do you want the buyer to have, the seller to have to do? So currently, in the current language, it says that a seller, it's a defense if the seller is reasonably, is relying on information from a public body or a licensed professional. So I push back on the House a little bit and saying, I don't even know that you need this language because I think there's already a defense. All a seller has to do, and I am not an expert in this area. I'm not out there buying property on a frequent basis, so I do have to somewhat defer to the experts in the room. But as I see the language, the seller, if they're going to a public body or they're going to a professional and they're saying, is my property in a FEMA mapped area? And that person is responding and saying, no, yes, I don't know. And they're providing that information to the buyer. They already have a defense. Okay. And so the question then is, if you want to add some additional protection, which is kind of what the House bill is doing, of saying if you've made some sort of reasonable attempt and you don't know, then you can say, I don't know. And so I don't know that you need to get that prescriptive about it. I don't know that you necessarily need to tweak the language, because even tweaking the language isn't changing the issue that Jim is raising. And Jim, feel free to jump in, not trying to put words in your mouth. The issue I feel like Jim is raising is going back to the beginning. Do you feel it should be the responsibility of the seller to do this? Because regardless of whether you're going with what I drafted, regardless of whether you're going with what Senator Chittenden, Gemini, ChatGPT pulled up, doesn't change the fact that a buyer would be able to bring a claim against a seller, and then the seller has to defend themselves. And whether it is by certifying they've consulted the publicly accessible online flood map and they cannot definitively determine, or whether it's they've made the reasonable attempt, or whether they're relying on what's currently there, which I feel if I'm the seller, that's what I'm going with. I'm hiring that professional and I'm saying, you tell me. And when the professional says, I don't know, I'm giving that information to the buyer. That's your most airtight defense as is, and that's already in statute.
And that's in statute in number 1 and.
That's in the D1.
In D1.
Current language,
right.
Yes, ma'am.
So Thomas.
I just want to officially say, I actually, from what Cam just said, I like Cam's language better than Gemini's. So this just makes sense. It's reasonable attempt. I think that's defensible and it tracks with what I understand full disclosure to be. So I think the language from the House is good.
You think it's good?
Yeah.
Well, so it just, again, it brings it back to, and I see Jim kind of came off mute there. If you want to invite him to jump in, going away from a reasonable, getting prescriptive, et cetera, it's not getting rid of the concern that has been raised, which is a buyer can bring a claim against a seller and a seller is going to have to defend against that claim. And the question is just, do you want a seller to have to provide this information? And if so, if that's the policy decision, yes, a seller should have to be able to provide some level of information here, then a buyer is going to be able to bring a claim. And the question is, you're wanting to put stuff in for a seller to defend themselves, and I think you've done that current law. And
so you think one covers this and is sufficient?
I think adding the two can be helpful, but it's just if I'm the seller and I understand that, you know, I'm an attorney, I work in statutes, I'm able to go find these things. It may not be as easy for a layperson to understand that this even exists. So I understand that, but if you are the seller and I can't ascertain whether my property is in a FEMA mapped area because either the map doesn't exist or it's one of the older maps that you looked at, then I'm going to go ask that professional to give me that opinion.
Yeah.
And when I get that opinion and I give that to the buyer, that defense is already in statute. I don't need to argue that I've made a reasonable attempt because I'm going to rely on D1. I'm going to rely on the public body or the licensed professional giving me the written report that they can't ascertain whether it's in a FEMA mapped area, and I'm giving that to the buyer. That's your sure defense.
Right. Got it. So we're going to return to this. We are going to, our Friday time is very tight. We're going to return to this for further discussion. I think I'd encourage us to let it sit with us till Tuesday, and we'll return to this on Tuesday. And if we do not include two for your order form, you're still okay, right? You can still, that doesn't affect.
You won't be able to say, I don't know.
You won't be able to
not, if you don't have, and that's why I'm saying two is a little bit of an expansive. I can understand the argument to be made to have it in because it allows for that I've made the attempt, I
But
can't ascertain
Instead
it.
of I don't know, you could also say, I've tried it, I've made the attempt. I mean, you could honor the fact that you've gone
Yeah.
to the
And
MP3.
who
You don't
knows?
need to say, I don't know. You could say, I certify that I've made the attempt to identify.
Right. And unable to determine was kind
And
of
I'm unable
the
to determine.
language that I thought we would go towards.
So can I flip the question? What would you find out that you wouldn't already know by asking the question, I am required to carry flood insurance or not? That we're asking someone to make sure they've gone and consulted maps that frankly are getting easier to look at, but not uniformly. That we now worry about the quality of going forward. So what we're doing is not something we do in most other aspects of real estate transactions, right? Like you're very much encouraged to get your own housing inspector. You're very much encouraged to, you know, take the responsibility that is required to not open a seller up to a subjective call
Right.
about whether or not they're giving you accurate information.
So I appreciate that, but I also appreciate that because FEMA is so now in jeopardy, and has not updated things as fast as we were hoping, that we may not know who is required to have flood insurance, because that
But
comes from
then-
FEMA.
That comes from FEMA, so does everything else you're
But
saying. So you're
No,
asking someone
no.
to look at a map that's very hard to look at, that
Right.
also comes from FEMA.
I agree, but we also are saying that there are other maps that are very good and are maybe more up to date.
We're not
So-
saying that, we're not saying that in statute. We
No, we're
couldn't
not
do
saying it in
that.
statute, we're saying it here. But my concern with asking, whether there are two questions, as you have identified, whether you're required to carry flood insurance or whether you are able to do it. Those are two.
But those are separate,
Those are
then,
separate.
did you look at a map?
But-
That's hard to
but-
look at.
But what I'm trying to say is that FEMA is the one who determines if you're required to do it or not. So they are not up to date, so their requirements are not
So
up to
I'm
date. That's all I'm
asking you,
saying.
what would you get from looking at a map that you wouldn't get from the question about the flood insurance? Nothing.
They probably
You're
not.
agreeing with me, nothing.
Yeah, because they're in sync in not being up to
Instead, you're
date.
just opening the seller up to a very subjective look at a map when we know a lot of sellers are older. I had a hard time last time. I mean, you saw it on the screen too. It's like, it has to load. We have to figure out how to zoom in together. We still don't know what we're looking at.
I would assume though,
But
older
most
sellers
states
would.
don't do that. So I'm really asking us what the responsible thing to do is here. And we should fix our mistake properly.
Okay.
I can't die on every hill.